Yes. Original court records ಯಾವ್ದು ಹೇಳಿ? Yes. Yes. Complaint is filed by proprietary represented by its director Appanna VT. Yes. Who has signed the wakalat? Yes, signed the wakalat. Okay. Yes, signed the wakalat. Okay. Wakalat. Yes. ಎಲ್ಲಿದೆ ಇವರ ವಕಾಲತ್ ಇದರಲ್ಲಿ ಮೇಡಮ್? ಅದು ಎಲ್ಲಿರ್ತಾವ? ಲಾಸ್ಟ್ ಇರ್ತದ? ಎಲ್ಲಿರ್ತದ ರೆಕಾರ್ಡ್ಸ್ ಅಲ್ಲಿ? ವಕಾಲತ್ ಕೊಡಿ. ಓಕೆ, ಇಲ್ಲಿ ಇದೆಯಲ್ಲ ಸ್ಪೀಕರ್. Yes.
Who is not the payee? The checker. This is one. He is one who pays of I1 properties. Not in the area of Karnataka.
Check. T1 is the check. IT Properties Limited. Yes. I1 Properties. Okay. Okay, it is issued in favor of IT Properties. I1 Properties. Yes.
I1 Properties does not fail the written complaint.
Yes.
As contemplated under section 142 of the Act.
Yes, sir.
A complaint is supposed not to register at all. Afterwards, yes, appear before the court and not in the court documents. At that time also he has not produced any piece of document so that he has the power to depose before the court.
Yes.
The first instance, Your Honor, the
Yes.
It was dated 21/11/2015.
21/11/2015. Yes.
On that day,
only 4 documents were marked. Yes.
Afterwards, I have cross-examined this witness on 28/12/2015.
Yes.
Until then, he has not produced any piece of document to show that he has the power to file the complaint. He has initiated the complaint on the basis of the CPA or resolution, whatever it may be. ನಾವು ವಿದ್ಯಾರ್ಥಿ ಕಂಪನಿಯ ನಿರ್ದೇಶಕ ಮುಂದೆ ಮತ್ತು ಸದರಿ ಕಂಪನಿಯ ನೋಂದಣಿ ಆಗಿದೆ ಆರೋಪಿ ಬ್ಯಾಂಕ್ ಡೆವಲಪ್ಮೆಂಟ್ ನನ್ನ ವಯಸ್ಸಿದ್ದರು ಆರೋಪಿಗೆ ಮುಂಬೈನಲ್ಲಿ ಆರೋಪಿ ಸಾಮಾನ್ಯವಾಗಿ ಯಾವುದೇ ಸರಿ ಆಸ್ತಿ ಸಂಬಂಧಿಸಿದಂತೆ ಎಲ್ಲ
Yes.
Next year, they have filed an application for marking additional documents.
ಆಮೇಲೆ ಮತ್ತೆ ಯಾಕೆ ಕಾಲಿ ಇದೆ ಮಧ್ಯಂತರ ಆದೇಶದ ಮೇಲೆ ಅಂತೇನೋ ಪ್ರಮಾಣ
HDFC ಬ್ಯಾಂಕ್ ನ ಪ್ರತಿಯನ್ನು ಪುಸ್ತಕವನ್ನು ಆರೋಪಿಸಿದ
Yes.
Unless producing this document before the court, he has not registered by the complaint. Section 142. He is not the payee. He is not having a operation.
Yes. Yes.
In the meantime, also may kindly see the executive file.
Yes.
Because it is issued on 14th of August. So get the
15th October.
15th October resolution get ಮಾಡ್ತಾರೆ issue ಮಾಡಿರೋ date ಇರುತ್ತೆ when that authorization was issued ಅನ್ನೋಕೆ date ಇಲ್ಲ.
Yes.
ಅವತ್ತೇನೋ resolution ಮಾಡಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ತಾರೆ.
Yes.
ಅದರಲ್ಲಿ when that authorization was issued to him, is the principal. And the authorization who has issued ಅನ್ನೋಕೆ ಯಾರು ಸೈನ್ ಮಾಡಿಲ್ಲ except these authorized persons. ಯಾರು authorized persons ಅಂತ ಮಾಡಿ company directors. No one has signed that. The IF law, the authorization is not given by the I-1 properties.
Yes. Yes.
But they have issued the authorization in first instance itself. It has to be accompanied with the complaint.
Yes.
The authorization letter has to be signed by the managing director, whatever paid.
Exhibit P6 ಏನದು
So, land development agreement.
ರಿಸೀವಿಂಗ್ ಅಮೌಂಟ್ ತಗೊಳ್ತಾ ಇದೆ ಬರ್ಕೊಡ್ತದೆ ಮಹಾದೇವಮ್ಮ. ಓಕೆ ಓಕೆ. Yes. Then
Since content itself is not maintainable.
yes.
Fire code and court have to have dismissed the complaint and acquit the accused.
Yes. Listen to it. Yes, 2000.
2009 701
2009 Criminal Law Journal NOC 701 negotiation rate. Yes, 190. Yes, 38.
Since there is a special provision of section 142A of the Act regarding the mode of law which cognizance could be taken. General provisions of section 190 CRPC would not be made applicable. Complaint not by waiving code of in due course.
Yes.
Complaint having not been by duly authorized person. The cognizance thereof would not be taken and the due was entitled to be done.
Yes.
Here also, at the time of getting the complaint, there's no authorization.
Yeah.
And the next one, our High Court judgment.
Yes.
Then, the entire
ಯಾವ ಪೇರ? Number 6. Yes.
The answer to the first point, I think, anyone can sense the criminal law in motion by the complaint of the price exceeding the amount of the magistrate. It can be comments on this whole project. The complaint was not drafted to the victim. However, this special statute states offenses and makes any special process or any process of such offenses under the statute. Then, complainant requesting the magistrate to take comments on the offense first satisfy the eligibility criteria prescribed by the statute. The only eligibility criteria prescribed by the section of the Act is that the complaint must be dated daily or older in due course. If the criteria is satisfied in the present case of hand, as the complaint is in the name of the company. This another complaint that a complaint must be authorized person who is capable of making a physical report. The complaint is made in name of the proper person. It is necessary that a natural person prevent such a report. The court depends upon the natural person to be compliant for all the practical purposes. All magistrates insist that a particular person whose statement was taken on board as a constitution can be continued to reflect the company in the end of the proceedings. There may be occasion when the different person can reflect the company. It would be open for each other any other person to reflect the company in court. Thus, even presuming that initially there was no authority, still company can at any stage rectify that. Therefore, the person responsible. Person, whether the person is competent and authorized to incorporate the body, such a company corporation, presenting the complaint, harmony all into the court within the governance of the complaint. If the complaint is on based behalf of paying or older in due course of the second person. However, should the person be raised by the court due course of proceedings or the objection raised by the accused, the complaint is bound to satisfy the court that the person prosecuting the complaint is competent and duly authorized to give incorporate complaint to representative. The contention that the person would be material only if there is a be raised by the accused to get this apparently taken by the inspiration from the by this court in case of Sarati leasing finance versus Narayana Shakti. So that case it was court has said back that the complaint had been filed by the managing director of the complaint company and that it was duly authorized under the articles of association to do so. Hence, the person that you had raised a plea in that regard did not arise at all. The observation was clearly which is unreliably and unnecessarily unnecessarily to be reported in this present case on hand, as case can be seen to the second of the trial court and partner court. The person has been raised by the accused and everyone has been prosecuted of this offense. However, the fact that the law requires a company and already party to carry on its enterprise in particular manner and the person whether the proceedings have been initiated and prosecuted in conformity with such requirements is a person that should be satisfied as a matter of course. I am not to depend upon whether an objection has been raised or a plea taken. The informative notice should be given. If the offender cannot be ignored as being a technical, it should be not be initiated the proceeding. Section 291 of Companies Act 1956 gives the anybody municipal debt subject to specified exercise concern. The director of the company, as its governing body, are entitled to exercise all the powers of the company. The initial case on hand is noticed by the court that the article of association of the company is about the power and is directed to sue or defend any questions on behalf of the company. The details of such powers can only be taken reserves of board of directors. Hence, a letter of authorization or a power of attorney executed by the chairman of the officer of the company without a delegation of a power to institute such proceedings having emanated from the court these proceedings but without the necessary authority. This lack of authority could have been supplied even before the court when the issue was consideration. Has been observed by the apex court in the was even on a concern that in the case of letter of authorization and the power of attorney having been executed, authorized the concerned person to write and prosecute the government that was an implied authorization by the court. It ought to have been formally ratified and the same was person with the court. This court has consequently elected for any person to present and tender evidence in court of law on behalf of the company ought to be authorized under the article of association of the company or by separate resolution with the board of directors. In the result, the proceedings are held to be initiated for the what authority to prosecute the complaint on behalf of the company by the power of the holder. Here was an authorization without specific power.
Yes.
But in our case, at the time of the complaint, there was no authorization at all.
Yes.
The next judgment. Being as the receipt of the complaint of an offense of which he is authorized to take action or which has been handed over to him, the second to make if he is with and then in a case here the accused is the second case commonly in the he exercise performing so the process against either the case himself or direct investigation to make the police officer also.
Yeah, ಎಷ್ಟನೇ ಪೇರ ಓದತ್ತೀನಿ ಯಾವ್ದು ನೀವು ಓದ್ತಾ ಇದ್ದೀವಿ ವರ್ಷದ ಲಾಸ್ಟ್ ಪ್ಯಾರದಲ್ಲೇ ಓಕೆ ಇನ್ ದ ಕಂಪ್ಲೇಂಟ್ ಎಸ್
There cannot be more witnesses than this complaint himself to be examined during the inquiry as because case
document.
During the inquiry, section 2 say the complaint cannot choose to examine any other witnesses which prevent inquiry may led only to scrutiny of the examination of the documents by the or with the whatever the nature of the inquiry is granted that magistrate must conduct an inquiry in order to find out whether there is a case for the purpose of discussion process. In the instant case, the complaint case within that the complaint was developed subject to a inquiry and has been section of the mandatory provision section 1 section 2 and therefore all of the getting on this process. This is right now. Independent application system for at the time of taking the ordinance itself, ought to have complaint, how the authorization to pay the complaint.
Yes.
Yeah, at the time of filing the complaint, there was no authorization.
Yes. ಅಲ್ಲ ಇದರಲ್ಲಿ ಏನ್ ಹೇಳ್ತದ ಕಾಗ್ನಿಸ್ ತಗೊಳ್ಳೋದ್ರ ಬಗ್ಗೆ ಇಷ್ಟ ಇದೆ ವರ್ಷದ್ದೇನ ನಿಮ್ಗೆ ಅದು ಬೇರೆ 202 ಎನ್ಕ್ವೈರಿ ಬೇರೆ 200 ಎನ್ಕ್ವೈರಿ ಬೇರೆ 200 ಎನ್ಕ್ವೈರಿ ಅದು ನಿಮ್ಗೆ ಅಪ್ಲೈ ಆಗುದಿಲ್ಲ 202 ಎನ್ಕ್ವೈರಿ ಯಾವಾಗ ಗೊತ್ತಾ ಕಾಗ್ನಿಸ್ ತಗೊಂಡ್ಮೇಲೆ ಮತ್ತೆ ಫರ್ದರ್ ಎವಿಡೆನ್ಸ್ ಬೇಕಾದ್ರೆ ಸೆಕ್ಷನ್ 202 ಕೆಳಗ ಅದು ಸೆಷನ್ಸ್ ಟ್ರಯಲ್ ಅದೆಲ್ಲ ಇದ್ರೆ ಮಾಡ್ತಾರ ಅದನ್ನ ನಾಟ್ ಇನ್ ಎನ್ ಐ ಆಕ್ಟ್ ಕೇಸಸ್ ಏನ್ರಿ ಎನ್ ಐ ಆಕ್ಟ್ ದಾಗ ಅಲ್ಲೇ only thing is you have to satisfy cognizance it is only prima facie there must be some satisfaction complaint document source statement the complaint has made out a prima facie case ashta mugita ashta cognizance so varsad ಏನಂತ help ಆಗುದಿಲ್ಲ okay next ಯಾವ್ದು ಹೇಳಿ ILR 2014 ಓದಿ ಏನಿದೆ ಯಾರ ಎಷ್ಟು ಓದ್ತೀರಿ ಪ್ಯಾರಾ 16 ಓದ್ಬಿಡುತ್ತೆ ಹೆಡ್ ನೋಟ್ ಯಾವ್ದು ಏನಾ ಬಿನಾ A okay complaint filed company signed by X who has no authority to file a complaint okay no authority to represent the company there is no release yes yes
our case is on hand is filed by the person who has no authority
yes
date of filing the complaint
yes sir yes
it's not a KE as conducted in section
142 yes
the complaint is not filed
okay So that's all. Yes, Mr.
Yes, my
Kumar
lords.
KG.
Yes, yes, my lords. My lords, the
Ah.
question raised by the my lords petitioner counsel is, my lords, the complaint has no authorized letter to my lords file the complaint, private complaint. My lords,
No, at the time of filing of complaint, he
yes.
has no authorization. That is why the complaint is bad. That's what addition and he related. Yes.
Yes, my lords. My lord, now I take my lords to complaint. Kindly see the complaint, my lords. In the
Complaint.
complaint alli, he
Before
has
trial court.
before trial court in the page number 7 of the complaint, he has produced, my lords, authorized letter, company incorruption letter. But my lords, that was not marked.
Page.
Page number 7 of the complaint, my lords. Along with complaint, list of witnesses and list of documents he has produced. But what that,
7. ಅದು ಲಿಸ್ಟ್ ಆಫ್ ಡಾಕ್ಯುಮೆಂಟ್ ಅದನ್ನ ಸೆಪರೇಟ್ ಮಾಡ್ತಾರೆ ನೋಡ್ರಿ ಇವ್ರು. ಎಲ್ಲಿದೆ
complaint, PCR.
ಕರೆಕ್ಟ್ ಪಿಸಿಆರ್ ಜೊತೆ ಇಲ್ಲಿ ಎಲ್ಲಿದೆ ಅದು ಸೆಪರೇಟ್
PCR ನೋಡಿದ್ರೆ ಅದರಲ್ಲಿ ಇದೆ ಪ್ಯಾರಾ 7 ಅಲ್ಲಿ, ಇದು ಪೇಜ್ ನಂಬರ್ 7 ಅಲ್ಲಿ.
ಅವ್ರದ್ದು ಲಿಸ್ಟ್ ಆಫ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಎಲ್ಲಿದೆ ನೋಡಿ. ಎಸ್,
ಕಂಪ್ಲೇಂಟ್ ಜೊತೆನೇ ಇದೆ. ಅದ್ರಲ್ಲಿ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ, ಬಟ್ ದಟ್ ವಾಸ್ ನಾಟ್ ಮಾರ್ಕ್ಡ್ ಆಫ್ಟರ್
ಅಪ್ಲಿಕೇಶನ್ ಲೆಟರ್ ಆಫ್ ಕಂಪನಿ. ಓಕೆ,
ಹೌದು. ಅದಾದ್ಮೇಲೆ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್, ಸೆಕೆಂಡ್ ಟೈಮ್ ದೇ ಹ್ಯಾವ್ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನ್, ದಟ್ ಟೈಮ್ my lords the document was marked.
Yes.
First, this is the first point, my lords. Another point, my lords, kindly see, my lords, the findings of the both trial court in this point, my lords. First, my lords, ಇದು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಫೈಂಡಿಂಗ್ಸ್ ಅಲ್ಲಿ, ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಫೈಂಡಿಂಗ್ಸ್ ಪ್ಯಾರಾ 8 ಅಲ್ಲಿ, ಇದು ಪೇಜ್ ನಂಬರ್ 8 ಅಲ್ಲಿ, ಪೇಜ್ ನಂಬರ್ 8 ಇದರಲ್ಲಿ ಇದು ಇನ್ ಪೇಜ್ ನಂಬರ್ 8 CC 4149 of 2015, the trial court findings, my lords.
Para
14 findings starts for resolution ಸಂಬಂಧಪಟ್ಟಂಗೆ findings
the
ಕೊಡ್ತಾರೆ.
light of the argument. Yes,
produced by the exhibit P5 resolution copy. It says that director may on 15/10/2014 this is, my lords, prior to the issuing of legal notice, my lords. The resolution was passed prior to the issuance of notice.
Yes,
it is admitted, and my lords, in the cross examination, the petitioner hearing, the accused did not disputed the contents of the resolution, my lords. They are disputing, they have not produced it, but they have not disputed the date of the resolution passed by the, my lords, petitioner company. They have not disputed, they have not questioned my lords. The date held on 15/10/2014, my lords.
Yes.
After discussion among the directors in length, authorized the PW1 to take necessary action against the accused. In the instant case, accused has not disputed the contents of exhibit P5 resolution. Much focus has made by the learned counsel for the accused on the evidence given by the PW on effect that he is the director of the complainant.
He is not the director of complaint.
He is not the director of complaint. At this juncture, it is necessary to observe that documentary evidence prevails over the oral evidence, and the admission must be used either as whole or not at all. It is equally settled that the sentence elicited in the cross-examination could hardly be construed as admission. In this regard, a reference may be made of the decision of the High Court of Karnataka, so and so, my lords. In next, the exhibit P5 resolution passed on 15/10/2014, and it is contents the legal
What
notice.
is this ILR 2008 Karnataka 3500? That is in respect of what? Here ನೋಡಿದ್ರು ILR 2008 Karnataka ನೋಡಿದ್ರು. Page 3500 ಬರ್ದಾರಲ್ಲ.
This judgment
ILR
says
2008.
ILR 2008 KR 3500.
Mrs. Yaki Raja versus Srimati Farida Khanum.
It is says that, my lords, the resolution is, if the resolution is period to the notice, my lords, the authorized person has got the authorized to file a complaint. It is valid. My lords,
Yes.
on 15/10/2014, and it is contents the legal notice issued on 8/11/2014 after the resolution, and complaint is filed on 23/12/2014 by the
Yes.
Sri Appanna VT, who is the complainant in this case. The issuance of legal notice and filing of the complaint by Sri Appanna VT is only after giving the authorization letter through Exhibit P5 resolution. The evidence placed on record by the complaint is sufficient to show that complaint is delegated and power by the association of the board of directors as per Exhibit P5. Under these circumstances, in this consideration opinion of this court, the contention of the accused to the effect of Appanna V, who is issued legal notice and filed the complaint, has proper authorization cannot be accepted. This is the, my lords, findings given by the trial court, my lords.
Yes.
And my lords, now the first appellate court, my lords, first appellate court also, my lords, held in first appellate court in page number 10.
First appellate court.
In page number 10, my lords, para number 19. How
Yes.
section 118, my lords, of the NI Act burden on the accused, presumption, my lords.
Yes.
I'll read the section, para number 19, my lords. Burden is now upon the accused to rebut the presumption available to the complainant. The defense of the accused is that complaint is not authorized to file a complaint and give evidence. To rebut the presumption available to the complainant, the accused relied on the cross-examination of the complainant. Now, I would like to refer the cross-examination of PW1. The counsel for the accused has put a suggestion that the complainant has not produced the authorization letter at all at the time of the filing of the complaint. The accused has replied that he had given to his lawyer. The complainant PWN has admitted that the authorization letter is not signed by the director and does not bear any seal of the company. He has further admitted that the joint venture agreement has to be entered on stamp paper and the agreement was not entered in the stamp paper. This is the Exhibit P6. The witness has voluntarily stated that since the accused was in urgent need of money, the agreement could not be entered in the stamp paper. The complainant has further stated that Exhibit P6 was written by the person who had come with the accused and either he or any of the director of the company, complainant, has not signed the Exhibit P6. However, he has denied the suggestion that he has obtained a signature on the stamp paper. Lastly, he has denied that the accused has not issued the check. And in order to take the money from the complainant, he has filed the false complaint. I have carefully gone through the cross-examination of the complainant. Nothing beneficially could be elicited from the mouth of the PW1 complainant. More so, it is not defense of the accused that he has not issued the check of the signature and the check is not in signature. Not his signature. The accused has not denied the issuance of and signature on the check. Under such circumstances, I am the opinion that defense taken by the accused is not acceptable. My lords, this is the trial court findings, my lord. Now, my lords, the evidence, I'll read the PW1 evidence, class of PW1 evidence. The relevant, my lords, I'll read. For authorization letter, my lords. Further cross examination of PW1.
Cross examination of
PW1, my lords.
Yes.
Last para second further class ಅಲ್ಲಿ authorization letter ಸಂಬಂಧಪಟ್ಟಂಗೆ ಕ್ರಾಸ್ ಮಾಡೋಣ. The defense counsel, my lords, the accused did not raise any question, my lords, about the date of the resolution, time of the resolution, the contents of the resolution. Nothing has been questioned about the, my lords, contents of the resolution. They only disputing, my lords. They also, my lords, they have not questioned the date of the resolution. So, my lords,
Yes.
Now, my lords, in the entire cross examination or the entire defense, they have not questioned the date of the resolution and the contents of the resolution. Now they are questioning. They have produced in the second, the after, my lords, after thought or after evidence of the PW1. Plus, in the cross-examination, it is clearly admitted by the PW that he has given the authorization letter to the advocate, and he has produced before the at the time of the filing of the complaint, but not marked, my lords. This is the only, my lords. I'll read that para, but they have not questioned about the contents and this one, my lords. Authorization letter ಅನ್ನು ದೂರು ದಾಖಲಿಸುವ ಸಮಯದಲ್ಲಿ ಹಾಜರುಪಡಿಸಲು ತೊಂದರೆ ಇತ್ತಾ ಎಂದರೆ ಸಾಕ್ಷಿಯು ಅದನ್ನು ಆಗಲೇ ನನ್ನ ವಕೀಲರ ಕೈಗೆ ಕೊಟ್ಟಿದ್ದೆ. ಸದರಿ ದಾಖಲೆ ಮೇಲೆ ನನ್ನ ಸಹಿ ಇರುತ್ತದೆ. ಸದರಿ ದಾಖಲೆ ಮೇಲೆ ಯಾವುದೇ ನಿರ್ದೇಶಕರು 3 ಹಾಕಿ ಸಹಿ ಮಾಡಿ ಅಂದರೆ ಸರಿ. ಆರೋಪಿಗೆ Ru 2009 so and so, my lords. This is the, my lords. Other than that, my lords, they have not questioned anything about the date, resolution time, and they have not questioned about the contents, my lords. Now, if they have not questioned the contents and, my lords, the date of the resolution, it is presumption that, my lords, the resolution was passed prior to the complaint, my lords, prior to the issuance of the check. They have given the authorization letter to the complainant for the presenting the, my lords, complaint, and, my lords, that is not questioned, and, my lords, that is presumption, my lords. This is, my lord, my point.
Yes.
And, my lords, in the facts of the case, my lords, she has admitted the transaction. She has admitted she went to the complainant place, and she had issued the check. She has admitted, and, my lords, but she has received the notice of the of the complainant. She has not replied to the complaint notice. And, my lord, she came to the court, but she did not enter to the box. They have not let the defense evidence, my lords. This is in the facts of the case, my lord. They have admitted everything. Now, my lords, the question of law, they have said the resolution was not passed, my lords, but they have not questioned the date, the contents of the resolution, my lords. Now, the presumption is that, my lords, if they have not questioned the date of the resolution, its presumption is that the resolution passed earlier to the issuance of notice and the presenting the complaint, my lords. This is my submission, my lords. Hence, I praise, my lords, to dismiss their complaint, the petition, my lords. Petition.
Yes.
Please, my lords.
This revision petition is filed. This revision petition under section under section 397 and 401 of the Code of Criminal Procedure, hereinafter shortly referred as CRPC. With a prayer to set aside the judgment of conviction and sentence passed by notice 25th judge, additional city civil and session judge CCH portal number ಹಾಕಿರ್ತಾರ ಇಲ್ಲ ಇದಕ್ಕೆ additional city civil and session judge number so and so in criminal appeal number 696 up to 16 dated 15/3/2019 wherein the learned session judge confirmed the judgment of conviction passed by the additional 17th additional Chief Metropolitan Magistrate Bangalore in CC number 4149 of 2015 dated 11/5/2016, wherein the accused is convicted for the offense punishment of section 138 of the Negotiable Instrument Act 1881, bracket hereinafter shortly referred as an act, and pray to set aside both the judgments and acquit the petitioner of the said charge. Next. The petitioner before this court was the accused before the trial court, and the respondent in this case the complainant before the trial court. The next part, the parties will be referred as accused and complainant as per the respective rank before the trial court for convenience. Next. The brief case of the complainant before the trial court is as under that the complainant is a company incorporated under the Companies Act 1956. It is further the case of complaint that in the second week of January 2014, the accused approached the complainant along with her husband and son, stating that she is the absolute owner of property bearing survey number 45/46 measuring 50 into 70 in survey number 25, situated at JP Nagara 6th phase, Bangalore. And they offered the complainant to purchase or develop the said property by entering into joint developing agreement. Believing the representation of the accused, the complainant agreed for the same. In this regard, on 21/2/2014, the accused requested complainant to pay a sum of 5 lakh as advance to clear some loans. The complainant paid rupees 2,10,000 by way of cash and rupees 2,90,000 by way of check bearing number 00160 dated 21/2/2014, drawn on HDFC Bank, Jayanagara branch, Bangalore. At the time of collecting the money from the complainant, the accused undertake to execute the joint development agreement in favor of the complainant. And if he fails to do so, the amount will be repaid within 15 days. It is further content that the accused executed a memorandum of understanding in favor of complainant after receiving the amount, and also husband and son of the accused also signed as a witness. Next, it is further content that the complainant thereafter got verified the documents through his advocate and came to know that the said property was already mortgaged to certain bank by availing the loan. In this regard, he inquired with the accused, and the accused admitted the same and admitted that she will repay the amount and requested not to take any legal action against her. The several occasion complainant requested the accused to repay the money. Subsequently, in the last week of September 2014, accused issued check bearing number 008042 dated 6/10/2014 for rupees 5 lakh, drawn of Bank of Maharashtra, JP Nagara branch, Bangalore. The complainant presented the same to the bank for encashment on 6/10/2014 through its banker HDFC, but the said check was returned with the endorsement insufficient fund. Thereafter, the complaint got issued notice to the accused through RPAD, though the said notice was served on the accused on 12/11/2014, the accused neither replied to the notice nor paid any amount. Therefore, the complainant lodged the complaint before the magistrate to take action against the accused under section 138 of the Act. Next. Before the trial court, the accused appeared. Thereafterwards, the complainant got examined himself as PW1 and got marked 6 documents. On behalf of the accused has not chosen to reduce any defense evidence after his statement under section 313 CRPC was recorded. Then after hearing both the sides, the learned Metropolitan Magistrate found the accused guilty of the offense punishment under section 138 of the Act and passed an order to pay a fine of ₹5,000, default to undergo simple enablement for 30 days. And under section 357(3), it directed the accused to pay ₹5,60,000 to the complainant towards compensation. In default, we shall undergo simple imprisonment for a period of 4 months. The same was challenged by the accused before the Sessions Court. The learned session judge in Criminal Appeal 696 of 2016 by his judgment and order dated 15th March 2019 dismissed the appeal and confirmed the judgment of conviction and order of sentence, which is now assailed before this court in this revision. I have heard Sri Prasanna DPL, right? Sri Prasanna DP, learned counsel for the revision petitioner, and Sri Kumar KG for a respondent. I have perused the appeal memo the judgment of the session judge and also the trial court and also the evidence on record from the above, ಅದಕ್ಕಿಂತ before to learned counsel for the petitioner, Sri Prasanna DP, argued mainly on one point. The learned counsel stated that under section 142 of the Negotiable Instrument Act, 142 ಅಲ್ಲ 142A of the Negotiable Instrument 142A na 142 only 142 not 142A, that is validation of transfer proceeding 142 of the NI Act. The trial court ought not to have taken cognizance of the offense under section 138 when the complaint in writing is not made by payee or, as the case may be, holder in due course of the check or its authorized agent or power of attorney holder. He relied on section 142 subclause A of the Negotiable Instrument Act 1881, which reads as under. Yes. The learned counsel further argued that if the trial court records are perused, when the complaint got examined himself initially, he has produced only 4 documents, which are marked as Exhibit P1 to P4, and which are only the check, bank endorsement, legal notice, and the postal acknowledgement. Hmm?
Bank endorsement. Postal receipts. You can notice what the postal receipt
P3, P3A, B, C ಅಂತ ಮಾಡಾರ. P3, P3A, P4 and P4 complaint. So the learned counsel argued that the cognizance taken by the trial court without there being a proper authorization to the person who has filed the complaint is bad in law. The learned counsel argued that the said authorization Exhibit P5 and the agreement rectifying receiving advance amount for joint agreement are produced subsequently by recalling PW1, that cannot validate or legalize the illegal thing. Therefore, the learned counsel argued that the said taking cognizance by the trial court is bad in law, New York section 142 of the Negotiable Instrument Act. In support of his argument, the learned counsel relied on a decision of the Punjab and Haryana High Court reported in 2009 Criminal Law Journal NOC 701 bracket ನಲ್ಲಿ P and H ಅಂತ ಇದೆ NOC. wherein in the head note of NOC, it is stated that complaint not filed by holder of check in due course and complaint not been filed to a duly authorized person, the cognizance taken could not be taken and accused or entered for acquittal. So the Lord Council stated that here also no authorization was produced. So the complaint filed by the authorization, complaint filed by the complaint without there being any authorization is bad in law. So the cognizance taken itself is illegal and the accused is entered for acquittal. The learned council relied upon another decision of Orissa High Court in laws. Iದೇನ್ ಬೇಡಲ್ಲ ನಿಮ್ಗಿದೆ ಇದೇನ್ ಬೇಡ judgment of this court in laws KR 2014 part 10 1990, wherein he relied on at para 6 relevant para para 6 alla you're relying on. Which reads as a para 6 type ಮಾಡಿ. The Learned Council argued that any of the principles stated in that decision, the proceedings are vitiated for want of authority to prosecute the complaint on behalf of the company. Therefore, prays to allow the petition and acquit the accused. Huh? Yes, yes. He also relied upon another decision of coordinate bench of this court. ಅದು coordinate bench ಅಂತ ಹಾಕಿ single judge ಅಲ್ಲ. IL 2014 Karnataka page 2168. And relevant para 7 and 16, para 16 So the Allied Council argued that in that case also, the person who has signed the complaint has no authority in law to represent the company, as there was no resolution authorizing by the company authorizing him to file the complaint. So the Allied Council prayed to dismiss this complaint. Except this, no other point is urged. Against this, the Learned Council for respondent, Sri Kumar KG, appearing through video conference, argued that this aspect is considered by both the trial court and also the first appellate court. Both the courts have concurrently held that the complaint is filed by authorized person and rejected the said contention. The Learned Council further argued that In fact, if the original records of the trial court are perused, the complainant, in fact, at the time of filing of complaint itself, has produced the said authorization letter, which is available in the record. Hello to Madam Mother. At page so and so, which is nothing but page 7 of the complaint. Therefore, the complaint along with the complaint itself, which is available at page.
Page number 7 of the complaint.
Index paper, wherein it shows that after the complaint, which ends at 6th page, this is the 7th page, wherein the list of witnesses, 2 witnesses were cited, and in list of documents, 5 documents, either note either type money. 5 documents were produced, wherein the 5th document is shown as authorization letter. The learned counsel argued that only as it was produced earlier, but due to oversight, it was not marked when the complaint led the evidence at the initial stage. Subsequently, an application was filed to recall the witness, and the said authorization letter, which was already produced along with the complaint, was marked as Exhibit P5 along with the other agreement. Therefore, the learned counsel argued that the complaint was filed by one Appanna VT, who is the director of the complaint, Mrs. I1 Property Private Limited, is competent in this regard. He has stated that the same was also mentioned in the legal notice issued to the respondent accused, and subsequently the complaint was filed. Therefore, there is a prior authorization before issuance of legal notice and filing of complaint. The learned counsel brought to the notice the discussion of the trial court and also the first appellate court at par number 19. In this regard, learned counsel argued that the said resolution was not questioned by the complaint, even he has not replied the notice. Therefore, the contention of the appellant at this stage, revision petitioner at this stage, is not at all tenable. Next paragraph. I have perused the judgment of both the courts and also records of the case. From the above material, the point that is for my consideration is whether the judgment of conviction and order of sentence passed by the learned session judge in criminal appeal number so and so, confirming the order of conviction sentence by the ACMM in CC number so and so is legal. Correct. and correct or call for any interference by this court. Next. On perusing the complaint, which is marked as Exhibit B4, it is evident that the complaint was filed by Messrs. I1 Properties Private Limited, represented by its director Appanna BP. And the complaint is also signed by the said person for I1 Properties Private Limited as an authorized signatory. But the seal and signature of the said person is appearing in all the pages, and he has verified the same. And in complaint at par number 2, it is stated that the said complainant is a company incorporated in the provisions of Companies Act 1956, and complainant company is represented by its director, and he is in charge and responsible for the day-to-day administration and affairs and the functioning of the complainant and company. He has also stated about issuance of legal notice. Which was served, and he has stated that the said notice was not replied in spite of service, and she has filed the complaint. And he has also filed his source statement by way of affidavit, wherein also he has stated on oath that he know the facts of the case, and he is the director and representative of the company, and he in charge of and responsible for the day-to-day administration of affairs of functioning of the company. And he has reiterated the complaint averment in his sworn statement. It is also evident that from the order sheet that when the complaint was filed, The learned magistrate in his orders of taking cognizance has mentioned that complainant himself is present, affidavit is filed, list with the documents is also filed. After verification of the same and after perusing complaint and document and source statement, he has stated that there is a prima facie case made out and took cognizance. And this complaint list of document as already referred above shows that this authorization letter was already produced along with the complaint itself. Therefore, at this stage, it cannot be said that the cognizance taken by the learned JMFC, the ACMM is either illegal or wrong. I have perused the judgment relied by the learned counsel for the appellant in the light of the evidence placed before the court. In the exams in chief, earlier he has produced only 4 documents. And in the cross examination, it is suggested that they have only obtained a blank check and a signature of the accused husband and her son on a stamp paper and on a blank paper. He has denied it. It is further suggested that in the month of August 2014, the accused have returned the money, and though they asked for return of the check, it was not returned. It is suggested that he is not authorized to lodge the complaint. He has denied it. And further, an application was filed on this authorization letter, and the receipt is also produced. And in the cross-examination by accused, he has clarified that the said authorization letter was already given, and it is signed by him. So this evidence corroborates his documentary evidence. I have also perused Exhibit P1, which is the check. Exhibit P2 is the bank endorsement. Exhibit P3 is the legal notice. P3A and P3B are the postal receipt and postal acknowledgement, and Exhibit P4 is the complaint. Next para. It is pertinent to note this Exhibit P3 legal notice was issued on 8 November 2014, and wherein the said council has clearly mentioned that the Messrs. I1 Properties Private Limited has given an instruction to him, and it is represented by its director, Sri Appanna VT, And as per his instruction, he has given this legal notice. Exhibit P5 resolution document shows that as per the resolution of the directors, the meeting held on 15th October 2014, I1 Properties Limited, in respect of taking legal action against this accused Srimati Mahadevamma for return of check by the bank, he was authorized to take action in the matter. And the name of Appanna VT is shown. The said resolution is not at all challenged by the accused, nor any reply notice was given to Exhibit P3 legal notice. It is evident that the resolution was passed on 15th October 2014. Subsequently, the notice was issued on 8th November 2014. As per the authorization issued by the company, as represented by Appanna VT. Subsequently, this complaint was also filed, wherein he is clearly aware that he is in day-to-day in charge of affairs of the company and he is authorized to file the complaint. Accordingly, he has signed the complaint. Therefore, the is not tenable. In the decision of George Joseph versus HMT Limited, the learned judge of this coordinate bench has discussed the various decisions at para number 6 of this court and also of Apex Court. As to who can file the complaint. And in the same decision itself, it is stated that relying on decision of Supreme Court in MMTC Limited versus Medchil Chemicals and Pharma Limited, 2002, Part 1, SEC 234. Anyone can set the criminal law in motion by filing a complaint of facts constituting an offense before a magistrate entitled to take cognizance. It is further observed by the learned counsel, learned judge, that under section 142 of the Act, the complaint must be a payee or holder in due course. That is the criteria satisfied at the initial stage. Here, the learned judge of this court has further observed that no magistrate shall insist a particular person whose statement has taken on oath at the first instance alone can continue to represent the company till the end of the proceeding. But there may be an occasion when different persons can represent the company. Therefore, the question whether a person is a competent and authorized to represent an incorporeal body, such as a company or a corporation, in filing or presenting complaint, would not normally be gone into in the court taking cognizance of the complaint if the complaint is on behalf of a PR holder in due course of the check in question. So this proposition of law is not at all disputed. Here in this case, when the complaint is filed, the complainant has produced the authorization letter. He is also aware that he is in day-to-day in charge of the company, and the order of taking cognizance itself shows that the learned magistrate, after perusing the complaint, documents filed, has taken the cognizance. Therefore, further, The learned judge of this court also held that under the Companies Act, authorization can be given only by a resolution of board of directors. Hence, a letter of authorization or a power of attorney executed by chairman or other officers of the company without the delegation of power to institute such a proceedings would invalidate the proceedings. Here, it is not a letter given by either a chairman or any officer of the company. The said exhibit P5 clearly indicates that it is the authorization given by the resolution in the board of directors as held by this court under section 291 of the Companies Act 1956. Therefore, this decision will not help the revision petitioner in any way. The next edition of Punjab and Haryana High Court in 2009 NOC 701 had not cannot be disputed at all. In that case, the complaint was filed person who is not duly authorized. So the cognizance taken is bad in law. That proposition has nothing to do with this case. Further, the decision in a CREF Finance Limited Kolkata Supra relied by the Direct Council is also of no use to the revision petitioner because in that case the complaint was signed by a person who has no authority in law to represent the company, and there was no resolution of the company authorizing him to file the complaint. That proposition is well settled and reiterated by this court and also the Honorable Apex Court in number of cases. And I have perused this decision also. In that case, there was no authorization. Therefore, the trial court has dismissed the complaint. But here, in view of, but here in this case, next argument, the learned and held that the TW1 being a director and authorized person, the complaint is competent. The learned judge of learned session judge in his judgment at para 19 has also in detail discussed as to how this complainant, who is examined as PW1, is competent to file the complaint and depose in this regard. Next, I have also perused the evidence of PW1, both exam chief and cross-examination. And the contents of complaint is affidavit and the evidence. Next, as far as the issuance of check signature is not denied by the complaint. Apart from that, there is a presumption under section 139 of the Negotiable Instrument Act in respect of issuance of check, and unless the same is rebutted by the accused, either by cross-examination of PW1 or by leading defense evidence, to show by preponderance of probability that the presumption is not available and the contents of the complaint is not tenable. Next paragraph. In this regard, the complaint has not led any defense evidence, and the cross-examination of PW1 does not disclose that the contents of the accused revision petition in this regard is tenable. It is not that Exhibit P5 is subsequently created or filed after the evidence is over. On the other hand, the legal notice itself mentioned that the said complaint is authorized by the company to represent the company. There was a resolution prior to that issue of legal notice. Subsequently, he filed the complaint and he has produced the said authorization letter along with the complaint. Simply because the council has not got it marked earlier and it was got marked subsequently, does not mean that it was not at all filed and there is no compliance of section 142 subclause A of the Negotiable Instrument Act. On the other hand, on perusal of the said section 142A of the Negotiable Instrument Act, the said and 138 of the Negotiable Instrument Act complied with the ingredients of the said section, and there is no merit in the arguments advanced. Further, on technical grounds, though in this case the accused has not denied the issuance of check and has failed to rebut presumption under section 118 and 139 of the Negotiable Instrument Act, and has proved the ingredients of section 138 of the Negotiable Instrument Act. Therefore, the contents of the original petitioner that the complaint in this case lacks the authorization to file complaint and lacks authorization to depose the evidence has no basis. It is evident that a director who is authorized and who has stated that is a person who is in charge of affairs of company for its day-to-day management and who has got knowledge about the company and who is authorized to issue legal notice and file the complaint which he has produced cannot be said as an person not authorized to file complaint or not authorized to depose. Neither the signature on checks was denied, nor the any defense evidence was led. Thus, the revision petition only sought to take some technical plea just to evade his liability, and this has no legal basis at all. On the other hand, what is required is the complaint must be the payee or the holder of due course. And if this criteria is satisfied and the complaint is in the name and on behalf of the complaint, then that satisfies the requirement of section 142. Here it is the I1 so and so is the person, he is a company which is the payee or the holder in due course. This is not disputed by the complaint. It has authorized the said person so and so to issue legal notice by engaging a counsel and lodge the complaint and given authorization by passing a resolution in the board of directors, which is evident from exhibit P5. 2002 could be the argument of the authority. The land council also argued that the director has not signed and it does not bear any date on. ಅದು ಇಲ್ಲೇ 2002 2021 Supreme Court ನಾಗ ಅದು that matter is already covered, sir. 2021 ಕೊಟ್ಟಿದ್ರಲ್ಲ ಮೇಡಮ್ 2021. Yes. Supreme Court in Bhupesh Rathod versus Dayashankar Prasad 2021. Same is dealt in 2021 in para 24. While we turn to the authorization, the presently it was a copy and thus does not have to be signed by board of members. And as that would form a part of the minutes of the board meeting and not a true copy of the authorization. We also feel that it has been wrongly concluded that the managing director was not authorized. Here also in this case, Supreme Court, the authorization in the case was only a copy and does not have to be signed by any of the board of members. You refer to AR 2021 Supreme Court 5726. The Red Council argued that no date is the otherly nadu ಸೇರಿಸಿಕೊಂಡ on perusing exhibit P5 it discloses the date of resolution which is by the board of directors authorizing the present complaint to lodge the complaint, simply because it does not bear the date when that authorization is issued, does not invalidate the resolution of the board of directors authorizing the complainant. You are not necessary. It need not be signed up 2021. It is not signed and it is not signed by anybody. On the other hand, the Supreme Court in addition reported near 2021 SC page 5726 at para 21, 23 and 24 considered the said aspect, and it is stated that it would be too technical a view to take to defeat the complaint merely because the body of the complaint does not elaborate upon the authorization. Here it has also referred to the authorization which was a copy and does not, and it is stated that it does not have to be signed by board of members as that would be formed a part of the minutes of the board meeting and not a true copy of the authorization. Therefore, the Honorable Supreme Court held that the conclusion that the managing director was not authorized is not correct. Further, the Honorable Supreme Court in a decision reporting year 2002 SC, page 182, while considering section 142 and 138 of the Negotiable Instrument Act in the case of MMTC Agalapam, has held that even if the complaint was lodged by manager or a deputy manager who had not been authorized by the board of directors to sign and file the complaint on behalf of the company, is not a ground to quash the complaint since said defect is curable, and it is held at para 10 and 11 that even after filing of the complaint, the company can pass a resolution and authorize the person who has filed the complaint, even though initially there was no authority. Still, at any stage, the company can rectify the defect at a subsequent stage and send a person who is competent to represent the company. Therefore, but here in this case, even at the time of filing of complaint itself, the complainant has produced it, and simply it was not marked due to oversight or some inadvertence is not a ground for the original petitioner to take such a stand. ಅದೇನಿದೆ ಆಂಧ್ರ ಪ್ರದೇಶದ ಆಯ್ತಲ್ಲ ಯಾವುದು ಇವರು ಜನರ ವರ್ಕ್ಶಾಪ್ ಇದೇನೋ ಆಗಲ್ಲ ಬೇರೆ ಕಾಲ ಇನ್ನೊಂದು ಡಿಸ್ಟೆನ್ಸ್ ಯಾವುದು The Honorable Supreme Court in decision report in 2008 Part 8 SCC 536 has elaborately discussed as to how a complaint under section 138 is to be filed by a company and what are the requirement of section 142A for taking cognizance of offense and who should represent the payee, where the payee is a company or a sole proprietary concern. and the said aspect was dealt at para number 9. Which reads as under. Section 142A of the Act requires that no court shall take cognizance of any offence consummated on the date except upon a complaint made in writing by the payee. Thus, two requirements are that a complaint should be made in writing in contradiction form an oral complaint, and complaint should be the payee, where the payee has endorsed the check in favor of someone else. The payee, as noticed above, is Messrs. Shankar Finance and Investment. Once the complaint is in the name of payee and is in writing, requirement of section 142 are fulfilled. Who should represent a payee, where a payee is a company, or how a payee should be represented, where a payee is a sole proprietor concern, is not a matter that governed by section 142, but by general law. So this is clear answer to your question. If it is filed in the name of I1 company, there ends the matter. Who represent is immaterial. That's what the Supreme Court says in the Shankar Finance versus. You just go through it, sir. Justice Ravindran Saibru judgment is. Justice Ravindran Saibru ಬರ್ದಿದ್ದಾರೆ ಬಹಳ ಬ್ಯೂಟಿಫುಲ್ ಆಗಿ ಬರ್ದಿದ್ದಾರೆ. He has dealt with everything. Okay. ಮತ್ತೆ ಯಾವ್ದಿದೆ ಇನ್ನೊಂದು ತೆಗೆದ್ನಲ್ಲ. ಹೌದು. ಇದಲ್ಲ 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 ಬೇರೆ ಇದೆ ಯಾವ್ದೋ ಬೇರೆ ತೆಗೆದ್ರೆ ಈ ಸಿವಿಲ್ ಮ್ಯಾಟ್ರ್ ಇದಲ್ಲ. Since no other, therefore, in view of the principle stated in the above referred decision and the evidence on record and the records of the case, if the judgment of trial court and which is confirmed by the learned session judge in criminal appeal or so and so are considered, it is evident that both the courts have rightly appreciated the evidence on record as per the settled principles regarding appreciation of evidence in dishonor of checks, which are popularly called as check bounce cases. Both the courts have rightly raised the presumption arising in favor of the complainant and have come to a conclusion that the accused revision petitioner has failed to rebut the said presumption. Regarding the cognizance also, the and requirement of section 142 and 138, both the courts have rightly come to a conclusion that the complaint filed by the said person is legal and proper. Therefore, in view of the reasons stated above, this revision being devoid of merits is liable to be dismissed. Accordingly, I pass the following order. The revision petition is dismissed. The judgment passed by the criminal learned session judge in criminal appeal number 696 of 2016, dated 15th March 2019, and wherein he has confirmed the judgment and conviction and order of sentence passed by Learned JMFC on 11th May 2016 in CC number 4149 of 2015 is hereby confirmed. Send back the records to the trial court. Yes. Check ಯಾವ year ಅದು? Okay. Sir, ಅವೆಲ್ಲ ಚೆಕ್ ಬೌನ್ಸ್ ಕೇಸ್ನಾಗ ಎಲ್ಲ ಕಡೆನೂ ಅದೇ ರೀತಿ. We don't know. We go by legal evidence. What is the check? What is the amount? How much he has given? How much he has returned? Check. It is known to the parties only. ಅದು ಏನಾಗ್ತದೆ ದಟ್ ಇದು ಲೈವ್ ಸ್ಟ್ರೀಮಿಂಗ್ ಇದೆಯಾ? ಮುಗಿತ ಲೈವ್ ಸ್ಟ್ರೀಮಿಂಗ್?
ಲೈವ್ ಇದೆ.